Item number 11, my lord. File is untraced, my lord.
Wait. Wait for Toyota. Yes.
Back to my item.
No. No. Wait.
Please, your lordship.
Item number?
19 may be adjourned for.
No. Rejected. Item number?
4 and 9.
Rejected. Yes.
But the matter was fixed today,
By which year?
24.
Go to the appropriate bench, not this bench. Yes, next case. Yes, call. Yes.
Your Lordship, I beg to mention item 8. Better mechanical password for the day.
No. Rejected. Yes. Yes, Mr. Item number? Item number?
1.
1. Yes, what is this?
Reason is directed against the order of husband and order dated 17/7/2009, passed by the appellate court.
Hmm.
It's a small matter. The petitioner, he has been convicted under section 498A for 5 months only, my lord. Fine of rupees 2,000, my lord. With all respect, my lord, the cruelty has not been proved, my lord, in this case.
Okay, let us see. Evidence of
W1 pays the informant, my lord.
Cruelty is proved, my lord, but demand of dowry
is
may
not
not
here.
be, except PW1.
Huh.
Others have not said, my lord. It is 18 years of marriage.
After
Marriage
18 days of marriage,
by,
But if demand of dowry is not there, how will you link it? Compelling.
that is true, my lord. But PW1 has stated. She says, my lord, 20,000 rupees was demanded.
that was the FIR,
And
my
due
lord.
to, my lord,
161 statement that is not
initially it
stated.
was lodged as complaint case, and thereafter it was sent.
What is
to
that
this-
deposition? Case 24 on note. Okay, PW1.
But others have said, my lord, she was assaulted, my lord, she was subjected to, my lord, torture. Actually, the petitioner has, my lord, remarried.
That is the main crux of the matter.
Another,
After 18 years of marriage, he wanted to marry another girl.
Any other proceeding?
No, my lord. In fact, my lord, he was in custody for 91 days during the trial. The informant, she has filed the application, bail application there, my lord. He was arrested on 8/3/2008, my lord. And the application was filed on 6/6.
Now, what is the present status?
Now both are living separately, my lord, adjacent this thing. And he is staying with the second wife.
Who is
with 2
maintaining
kids.
her?
He himself is maintaining. He is paying some amount.
Anything on record?
No,
that
my lord,
good?
that is not on record, my lord. The first wife, she has got 3 children, and the elder, everyone has become major, my lord, and her daughter has been married off, my lord.
formal
And-
divorce has not taken place.
Yes, my lord.
Huh?
Divorce has not taken place.
Who are the other witnesses?
Other
My lord,
witness,
even daughter is there, my lord.
daughter, and the
His daughter
brother
is there. And sister-in-law, brother of the, my lord, accused, petitioner. Elder brother of the accused.
Even nobody has stated anything about directly about the assault part, but everyone has said that Kazia Lagise, that is the statement, my lord. They stayed in adjacent house. Whenever there is some Kazia between the
Will acquit. Heard Mr. R. Shekhar, learned counsel for the petition. Also, Mr. D. Das, learned additional public prosecutor. The present application under section 401, read with section 397 of the Code of Criminal Procedure 1973, is filed assailing judgment and order dated 24/6/2009, passed by learned Judicial Magistrate First Class in GR case number 423/2007, whereby the petitioner was convicted under section 498A and was sentenced to according to the IPC and was sentenced to undergo RI for 1 year and to pay a fine of rupees 3,000 in default simple imprisonment. In default of payment of fine, another period of simple imprisonment for 6 months. Okay. The further challenge is an order, the judgment and order dated 17/11/2009, passed by learned Additional Session Judge, FTC, Nagaon, in criminal appeal number 17 within bracket N/2009, whereby the judgment, conviction and sentence dated 24/6/2009 was upheld, and so conviction dated Swenso was upheld. However, the sentence was reduced to 5 months of rigorous imprisonment, and the fine was enhanced to an amount of rupees 2,000 rupees. Full stop. Mr. Sekhar, learned counsel for the petitioner, referring to the judgment of the learned courts below, as well as referring to the evidence of PW1, the victim wife, PW2, and other PWs who are independent witnesses and relatives of the victim, submits that the necessary factum of cruelty as well as demand of dowry has not been proved, and admittedly, the marriage was a subsisting marriage of 18 years, and the affair was lost at a very belated stage, even after the alleged date of incident. Full stop. Therefore, the judgments are vitiated by perversity, and this is a fit case where this court should exercise its power under section, exercise its revisional power to cure a patent defect. Per contra, Mr. D. Das, learned additional public prosecutor, submits that both the courts have concurrently found the petitioner guilty of committing the offenses, and therefore committing offenses on the basis of the material evidence produced by the prosecution on record, and the prosecution has been able to prove the case beyond reasonable doubt. In view of such concurrent findings of fact, this court may not interfere with such well-reasoned judgment in exercise of its power under section, in exercise of its revisional power. I have given anxious considerations to the arguments advanced by the learned counsel for the parties. Then revision part. Why revision? Where is that? Revision part two already. The next, we should pull up. Now, continuous dictation. As the learned counsel for the petitioner has assailed the judgments primarily on the issue of perversity, this court has perused the material, perused the evidences produced by the prosecution, also perused the judgments by the learned courts below. The prosecution case in nutshell is that the victim had been married to the accused petitioner for 18 years as per Islamic rites, and out of their wedlocks, 2 daughters and 1 son was born to them. And it was alleged that since last 1 year from the date of lodging of the FIR, the accused has been demanding an amount of rupees 20,000 and often tortured the informant due to failure on her part to fulfill his demand by bringing the same from her parents' house. And for these reasons, on several occasions, she was also sent back to her parents' house. And full stop. It was further alleged that though at the intervention of the victim's father and some well-wishers of her family, the informant returned back on several occasions to her husband's house, yet her husband accused repeatedly tortured her and also announced that he would marry his own marry somebody else. Full stop.
Initially, it was my lord lodger's complaint.
Ah,
Yes.
ah.
After my lord, it was
Okay,
sent to the
okay.
exhibit
And-
one.
and প্রথমত an FIR নয়, a criminal complaint case was registered before the jurisdictional magistrate,
Yes.
jurisdictional judicial magistrate,
Exhibit 1.
which was sent to the jurisdictional police station accordingly, inter alia alleging এই কথাখানি যে করুন, the disease, which was registered as Koliabor PS case number 77/207. After completion of the investigation, during the course of investigation, the statement of the victim under section 164 CRPC was registered and
Exhibit 4.
huh?
Exhibit.
Registered, and subsequently, after completion of the investigation, the investigating authority filed search sheet under section 494/498A IPC corresponding to GR case number 423/07. Subsequently, charges under section 498A was framed against the accused petitioner, to which the petitioner pleaded not guilty, and accordingly trial commenced. During the course of investigation, during the course of trial, as many as 6 witnesses were examined by the prosecution to prove the guilt of the accused petitioner. The statement of the accused was recorded under section 313 of the CRPC. However, the accused did not lead any defense witness, isn't it? No. Okay. After completion of the trial, learned trial court convicted the accused petitioner under section 498A and as recorded herein above. Being aggrieved, an appeal was preferred, which was registered as criminal appeal
17, my lord.
17 within bracket N/2009, and same was also dismissed with certain modification in the sentence as recorded herein above. Full stop. Okay. The victim statement under section 164 was exhibited through the victim and was marked as exhibit 4.
I have flag marked it.
Exhibit 4. In her statement under section 164 CRPC, the victim reiterated her stand that marriage has been subsisting for 18 years. However, since last 6 months, her husband expressed his willingness to marry another lady and started to ignore the victim and started to beat her up. During her evidence as PW1, she stated as regards demand of dowry of 20,000. And here also she testified that her husband wanted to marry one Rehana Khatun, who was previously married to another man, and after her divorce, she is maintaining a relation with the husband of the victim. When she went to complain as regards the relation between her husband and Rehana to the father of the Rehana, namely one Subham Ali. However, said Subham Ali threatened her, and accordingly she lost the affair. This is the story. During your cross, you have reaffirmed. In her sleep, she has not said when money was demanded. During her cross-examination, she deposed that money was demanded 2-3 months back, and she lost the affair. She lost the complaint after a month from the date of injury. He denied the suggestion as regards demand of dowry of rupees 20,000. The other witnesses, though other witnesses have affirmed as regards as regards their marriage, that they as regards the marriage between the accused and the informant since last 18 years. They also deposed that there are that quarrel used to happen between husband and wife, and they had expressed that they are not aware of demand of any money. Ah. The daughter of the accused and the informant was examined as PW3, and she affirmed a relation between her accused father and one Rehana, and that there were quarrels between husband and wife for visit of the accused to the place of said Rehana. And according to her, the affair was lost on the date when the accused married the aforesaid Rehana. PW, Mr. Rajsekhar, PW wants cross-examination and PW4 evidence that you used to beat her up remain unsecond. So cruelty is there.
Cruelty is there.
Cruelty is
That's
there.
what I say.
Even demand is also
Cruelty is-
demand is reaffirmed, including date.
They
In
were also
PW.
question in cost my lord.
Maybe, but we are judge is to look into what the materials and that too in a revision. So it's not a case of acquittal.
So Lakshmi, then in that case means converted to pure underground my lord.
Period undergone.
Yes.
Period undergone. Yeah, because we cannot maybe husband and wife, but there are materials. We cannot ignore this.
One sentence is there, my lord.
One sentence is enough.
Yes, my lord.
Your senior used to cross-examine one or two questions only. That's enough. One question is that, yes, demanded,
At the time of the incident, he was a mason, my lord, and now he is a cultivator. So,
maybe.
as because he's
No,
not
that
called-
we are, that had it been a government employee,
Yes,
would
yes.
have thinking different. Okay. Through the PW 4, the prosecution, no. The PW 4 is an independent witness.
In law, this person.
Okay, no. PW 4
বয়েক হয়।
is the sister-in-law, দেওর হয় না? Sister-in-law of the accused person. She specifically deposed that the accused used to beat the victim and she used to stay in their place out of fear and out of such beating. And she deposed that she witnessed such cruelty by the husband upon the wife. She further deposed that once the victim was beaten up and she went to her parental home, and then the accused brought the other lady, Rehena, to their residence. During cross-examination, she reaffirmed that though she cannot state the date as regards cannot affirm the date. However, she deposed that on the space said date at around 11 p.m. she was beaten up by the accused. PW5 also deposed that he has not seen any attack by the accused. However, he has learned it from others, so his evidence was not so relevant. From the material as recorded herein above, the learned trial court has concluded that the husband petitioner, meted with cruelty upon the victim wife, compelling her to leave her matrimonial home, and that there was demand of dowry of rupees 2,000. Such factual proposition was reaffirmed by the such factual conclusion of the learned trial court was affirmed by the appellate court after reappreciation of this after reappreciation of evidence. Reappreciation of evidence. To convict a person under section 498 CRPC, the prosecution is to prove 498A. come on, come on. Prove your case. The prosecution is to establish that the married woman has been subjected to cruelty or harassment by her husband or relatives, which can be physical, mental, or emotional. 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 In the case in hand, in the case in hand, the PW1 evidence that she was beaten up and there was a demand of rupees 20,000 had remained unshaken. The marriage between the accused and the informant had also not been disputed. In fact, through the during the cross-examination, the victim reaffirmed the period when the demand of rupees 20,000 was met. Through the evidence of PW4, it was the cruelty was further established. In view of the aforesaid evidence, after appreciating the aforesaid evidence, the learned courts below has concurrently convicted the petitioner and concurrently convicted the petitioner under section 498A CPC. The object of revisional power of this court is to set a patent defect or an error of jurisdiction or of law. Such power can be exercised where the decision under challenge are grossly erroneous, there is non-compliance with the provisions of law. The findings recorded is based on no evidence, or material evidence is ignored, or judicial discretion is exercised arbitrarily or perversely. It is equally well settled that revisional jurisdiction of High Court should not be exercised in a routine manner, more particularly against concurrent findings of fact. The Honorable Apex Court, in the case of Chandra Babu versus State, reported in 2015 8 SCC 774, held that normally revisional jurisdiction should be exercised in a question of law. However, when factual appreciation is involved, then it must find place in the class or classes of cases resulting in a perverse finding. In view of the aforesaid full stop. In the case in hand, as recorded herein above, this court has not found anything as regards any patent defect or jurisdiction or law. The decision arrived at by the learned courts below. No, just delete it. In the considered opinion of this court, and as recorded herein above, the learned courts below had duly appreciated the evidence on record, and conclusions arrived at are on the basis of such appreciation of evidence. Full stop. This court has also not found anything to suggest that the conclusions so arrived are based on no evidence, or that material evidence has been ignored. In view of the aforesaid, in the considered opinion of this court, this is not a fit case for exercise of its jurisdiction, revisional jurisdiction, to interfere with such concurrent finds of fact. Full stop. Final call. At this stage, Mr. Shekhar, learned counsel for the petitioner, submits that the the sentence should be modified and the period already the period the petitioner was in custody should be treated as the period of conviction. This court has considered aforesaid aspect of the matter and is of the opinion that the petitioner has in the meantime suffered by facing trial, then appeal, and at this revisional stage, inasmuch as the alleged incident took place on such and such year, and we are deciding this matter at this stage. So considering the above, this court is also of the view that the sentence be modified and it is provided that the, how do you say it, sentence undergone, period undergone, and it is and sentence be treated as the period already undergone by petitioner, which is 90 days,
91 days.
91 days in custody during the period of we'll modify this improperly. LCR be returned back.
Fine part, my lord.
Fine part he will pay.
Deposit fine part and it will go to the, my lord, victim, my lord.
The fine be deposited before the learned trial court below by the petitioner within a period of 2 months from today. Are you having any connection?
Yes, my lord.
Okay, 2 months from today.
Fine could be perhaps.
And same be, huh?
Fine perhaps could be. Because 2010, that 2010,
Okay, we'll consider it before the learned.
He's maintaining the process.
Yeah, you have done injustice to her.
Yes.
To the learned chief judicial magistrate, which shall be given to the victim.
Possible.
LCR be returned back. We'll modify it. We'll get it by weekend, the order. Yes, what is the next case?
The provision is for 98A, my lord.
Mm.
Here, my lord, of course, in between the husband and wife, my lord, already wife has got married to some other persons and they have signed an affidavit, my lord. I have filed an additional affidavit.
Where is that?
Fine.
What do you do?
Not already, it has been compromised between them, my lord.
What do you do?
We may close all these things because since,
No, what do you do? You are a government employee, some cultivator.
Not a government employee.
Where is the affidavit?
Lordship will additional affidavit and their affidavit lordship will find at page 4 lordship.
Whose affidavit?
This both, this
Page
page 4, my lord,
4 of the?
of my additional affidavit, my lord.
There is no additional affidavit. Please see, look into this. When did you file the additional affidavit?
19, my lord, 18/2/2019 lord.
Please. In 2010. Who is representing her? Huh?
But you kindly have a look the contents of
No, we'll go to the contents. There is direction, notice to be issued. Notice is served or not. You have filed an affidavit. Why should we straight take note of it until and unless she is here? Respondent number 2, no steps taken.
Earlier occasion probably. Earlier occasion only state of Assam, now so
No, you are not aware. You have taken steps on 2110. Initially, she was not party. Court directed you to make a party. Third, Mr. Chetri, learned counsel for the petitioner, also Mr. B. Sharma. The present application is filed. What was the period? Petition application file under section.
498 RI for 6 months.
This criminal revision petition is filed assailing an order, a judgment dated 11/12/2009 passed by learned Judicial Magistrate First Class, Biswanath Sariali in GR case number 419/06, whereby the accused petitioner was convicted under section 498 IPC for 6 months and to pay and rupees fine and to pay a fine of rupees 2,000 and in default simple imprisonment for another 1 month. The further challenge is an order, judgment and order dated 4/3/2010 passed by the learned additional session judge FTC in criminal appeal number 1 within bracket S-1/10, whereby the judgment and conviction dated 10/12/2009 was upheld. Though notice was issued to the respondent / informant wife, however, office note dated 21/10/2019 reflects that notice were not returned. Full stop. Few of the notice were not returned, and those steps for steps were taken through registered post with AD. However, on 21/10/2019, however, such no AD card has been returned. Considering the above, the service is presumed. Mr. Chetri, learned counsel for the petitioner, submits that during the pendency of this revision petition, the husband and wife has amicably settled their dispute. That in the meantime, amicably settle the dispute in as much as the informant wife has in the meantime remarried with one Sri Bijoy Bhukhan Dev on 11/4/2016, and she is living peacefully with her living, and she is leading her peaceful married life. Full stop. In view of aforesaid, it is also contended that in view of the aforesaid, they amicably settled their dispute, and an affidavit was sworn in before whom? Before the executive magistrate Vishwanath Sariali. And accordingly, an additional affidavit has been filed incorporating the aforesaid affidavit. This court has perused the affidavit. The affidavit. The learned, the wife has not entered appearance to raising any dispute as regards this additional affidavit, as well as the affidavit annexed, executed before the executive magistrate Vishwanath. Executive Magistrate Vishwanath Sariali. As per the aforesaid affidavit, the wife has declared that she got married to Sri Binoy Bhushan Dev, son of Rohini Mohan Dev, resident of Ward number 4, Rangapara Town, District Sonitpur, Assam, on 11/4/2016, and have been living a peaceful married life with her present husband. It is further stated that the wife, therefore, is not interested that the dependent number 1 be punished for the offence under section 498A IPC in connection with GR case number 419 of 2006. Then power of this court, there is a order already. Power of this court under section 482 to compound an offence. 498A, ask for Mr. Nath. In view of the aforesaid, in the considered opinion of this court, this is a fit case to exercise its power, to exercise its power under section 482 CRPC on the issues being settled by the husband and wife, more particularly when they are living a separate peaceful life, and sending the petitioner to undergo the sentence will not meet its purpose. Okay, disposed of. Unnecessary, these matters are pending since 2000.
There are also concurrent finding below. By trial court, conviction under section 323 by 326 IPC. Then on appeal, my lord, it was
What is the sentence?
learned magistrate passed 6 months for 323
Mm.
and 3 years for 326. And appellate court, my lord, altered the conviction under section 324 by 323.
Okay.
326 is gone, my lord.
Gone.
And sentence 1 month for 323 and 1 year for 324.
Who are the injured witnesses?
My lord, injured witnesses PW 2 and 3.
Your lordship.
PW
And PW 3, your lordship.
PW
2 and 3. my lord.
Three.
PW 2 and PW 3. Injured victim.
Injured witness. PW 4 is also eyewitness, my lord.
PW 4 is
Eyewitness. PW 5 is declared hostile.
witness. PW 5 hostile.
PW then, my lord, other witnesses, my lord, heard the matter.
Hearsay.
Yes,
Forget
hearsay.
revision will not
Yes,
discuss
yes.
each and every. Who is the doctor? Any medical?
Doctor is, my lord, PW 9.
PW 9, your lordship.
PW 9. He supported prosecution's case.
My lord support.
Okay.
Injured,
Now
he was-
any exhibit.
victim has to be, my lord, had to be operated upon.
Okay,
because of head injury.
okay.
And one is stabbed. The PW3 was stabbed in his abdomen.
No, any medical exhibit,
Medical exhibit,
medical report, any exhibit?
that is doctors. Ogman answer videos.
Are you ready? Okay. I want the evidence of the injured witness,
Yes.
doctor, any eyewitness, or any contradiction, any doubt, anything. That's all. Okay, we'll come back to this case a little while, go through it. Huh?
Right.
Next case, call the next case. We'll decide this today. Yes, what is the next item? Who is your senior?
Medical condition.
P76. What is the statement of the victim? You read it, do it too. No adjournment. We'll appoint an amicus and hear it. That's all.
Day after
No, no,
vacation.
2010 meter.
Day after vacation, my
No, forget about vacation. Not even day after tomorrow. What is the sentence?
Well, here, initially it was RI for 7 years and fine of rupees 5,000.
Mm.
In default, SI for 1 year.
Mm.
Thereafter, it was in appellate court, it was reduced to modified and reduced to RI for 5 years, and fine remains the same. And PW2 is the victim, my lord, in 1/6. The deposition, it was clearly implicated the accused person, my lord. And PW3 corroborated the PW2, my lord.
What is the evidence of Hazarat and Mohor? They are
Right.
examined.
My lord, examine, my lord.
Hazarat is
PW3 and PW4 both of them.
PW3, Mohor is PW4.
My lord. They are corroborating, my lord.
Who is your senior? There are two convicted or one?
My lord.
Jamiluddin.
My lord. Only one, my lord. Only one. Accused number one, my lord.
We can give you a one chance of doing this case on Thursday. Okay, then we'll do it today itself. By appointing amicus. We'll record that. On who are the other lawyers in the case? Everybody is there.
My lord.
NN Jha is there. Dean Ondi is there. K. Rajbangshi is there. There is no question. There is a question of wakalatnama. We'll say misconduct. As simple as. Thursday, we can adjourn. And if you say that he cannot do on Thursday, have your instruction from your senior. At best, we can take up this matter on Thursday. And if not, we'll appoint an amicus. Have your instruction and come back. Yes, next case. None appears for the petitioner on call. The present application, a present criminal revision petition is filed assailing judgment and order dated 10/2/2010 passed by Learned Subdivisional Judicial Magistrate SDJM Nagaon in MR case number 58/09 under section 125 CRPC. CRPC. The brief facts of the case is that is to the effect that the respondent wife preferred an application under section 125 CRPC praying for maintenance, which was registered as MR case number 58/09. It is the case of the respondent wife that she is legally married wife of the petitioner and marriage was solemnized as per Islamic rites and customs. Full stop. And out of the wedlock, 2 children were born to them who were aged about 7 years, who were minors. Full stop. It is her further case that after birth of the second child, the husband started to torture her on illegal demand of dowry, comma, she was subjected both physical and mental torture at her matrimonial home, and she was driven out of her matrimonial house. Full stop. According to her, the husband, even after having sufficient means to maintain her and the children, he refused to maintain them inasmuch as he is owner of a grocery shop. Full stop. Notices were issued to the respondent husband, who contested the case by filing written statement. He denied all the allegations made against him. His stand was that first party did not perform the duty of wife, and she insisted, and the wife insisted him to stay at her parental house separately from her in-laws, and she left her matrimonial home at her own will. Full stop. It was his further stand that the second party tried to take his wife back to his residence. However, she did not return. The petitioner examined witnesses in support of her case. I'll share. Case. See. Case. The wife examined herself as PW1. And one Khairul Islam, the father of the complainant, as PW2. The petitioner examined himself as DW1, and one Hassan Ali as DW2. After appreciation of the aforesaid evidence, the learned trial court below came to a conclusion that the first party has sufficient means. No, not first party. That the first party did not have sufficient means to maintain herself and her children, and that the second party, that is the husband, had sufficient means to maintain the wife and the children, inasmuch as the second party had taken a stand that he daily labors and earned his bread and butter by working at different places, and therefore when he is an able-bodied man and earns even by daily even by daily wager, he is liable to maintain his wife and children. Accordingly, an amount of rupees 800 per month was awarded in 800 per month as maintenance was awarded in favor of the wife and rupees 500 each per month for the children. Full stop. This court has perused the evidence of PW1, perused the evidence which is part of this record. And her statement as regards alleged torture, demand of money and non-maintenance remain unshaken. Though the defense tried to project that the husband did not have monthly income of rupees 15,000. First of 15,000 and the projection of the wife that he had having a grocery shop, grocery shop, and had also projected that he did not have any grocery shop as projected by the wife. From the material available on record, what is seen is that the husband has not disputed the marriage. What is disputed is that he is a daily wage earner and therefore could not maintain his wife and children, and that the wife had voluntarily left the house, her matrimonial house. Full stop. The learned trial court has duly appreciated the aforesaid materials on record and came to the conclusion as recorded herein above. This court is of the view that such in a proceeding under section 125 CRPC, which is summary in nature, the fundamental thing is required to be proved is that the wife has not been able to maintain herself and the husband having means has neglected the wife and children to maintain. Full stop. In the considered opinion of this court, the respondent wife has satisfied and proved the aforesaid conditions, and through her evidence of PW1, full stop. The case of the defense that he is not owner of a grocery shop and he did not have an income of more than 15,000 has also duly been considered, and the award was passed by the learned magistrate on the basis of the defense case that the husband is only a daily wage earner, and accordingly the maintenance was awarded. Full stop. In view of the aforesaid, this court finds no perversity in the aforesaid decision. It was and the said order has reasonably passed after appreciation of evidence. Accordingly, this court is not inclined to exercise its revisional jurisdiction to interfere with the impugned order. Accordingly, revision petition stands dismissed. While parting with the record, it is made clear that this order shall not debar the parties to prefer application under section 125 CRPC if so advises, inasmuch as this matter is pending since the year 2010. Full stop. And there may be some changes in circumstances. Next.
3 minutes, I have flag marked the injury.
Okay. We'll come back at 2.
Well,
Those we need certain applications, yes.
Wait, please.
Yes, what is this?
Concurrent judgment, my lord, convicting the petitioner, my lord,
Under
for
section
3A, my lord, of
of,
railway properties unlawful
what did you do?
possession. Business, simple business,
Huh?
small businessman, my lord.
What is the period?
6 month, my lord, conviction. Most importantly, the petitioner is not the owner, my lord, where the railway properties were, my lord, found, alleged to be found.
Who is he?
He's a businessman, my lord, petitioner, my lord.
Oh, businessman. How it was what is the section under 140?
Three,
143. What
Section
is the
3.
ingredients of 143? What is required to be proved by prosecution?
my lord, the possession, my lord.
Possession. Now, who proved
Kindly
the
peruse, my lord,
who proved the possession? We'll peruse everything. Who proved the possession? Prosecution.
prosecution, my lord.
Prosecution through which witness projected to be prove the possession from you. Two things. One is that it should be established as a railway property.
My lord.
Second thing is that unauthorizedly it is in your possession.
Yes.
Two things. Now, so therefore prosecution is to prove beyond
Tell
reasonable
us on the
doubt
part.
these two parts,
My lord.
that this is a railway property and that it is been recovered from your possession. Who are those witnesses?
PW9, my lord, the Gaunbura, who has issued the certificate, my lord, certifying that the land is belong to the petitioner.
Land is belong to the petitioner.
Kindly peruse it.
We will peruse it. We are just understanding.
And my lord, the railway
See, one
properties.
thing is clear. We are not going to give an status of an first appeal.
Yes, my lord.
And we'll give
The
that
revision.
too when we understand that there is some grave error.
My lord.
We may reverse it also. So therefore, you just tell us first, we'll go to the details.
First of all, my lord,
How it was proved to be railway property?
it was not proved, my lord.
Tell us that
not
first.
exhibit.
First part is not proved.
Yes.
And and it was recovered from whose place?
One, my lord, scrap go down, my lord.
One scrap go down. Now, who is the owner of the scrap go down?
That scrap go down alleged to be the owner of the petitioner. But
Okay.
the Gaunbura issued the certificate on the
Gaubura was examined.
on the
What did he
dictation of
say?
the informant, my lord.
What did he say?
PW9, my lord.
Who proved it to be a railway property? Tell us first.
The informant, my lord, railway authority.
What was the material?
It will be some many other materials, my lord. His plate and all, my lord.
Okay, certain things are there. If you can prove it that this is
Nothing has
the.
been exhibited, my lord.
No, you may not exhibit a railway wheel. Rail wheel you may not exhibit. Seizure release is sufficient. That this was seizure is proved that this was with independent absence railway wheel is there. So please tell us who are the witnesses, seizure witnesses.
Before that, kindly page PW9, my lord.
We will come to PW9. Please let us understand who are the seizure witnesses.
These are witnesses your lordship will find. All are there is no independent witness in the
We'll come to I am not asking you who is independent. I am asking you who are the seizure witnesses.
my lord.
Next question will be whether independent witnesses is there
3, 4,
and whether
5,
independent non-availability of independent witnesses is a fatal to your case.
my lord.
Yes, tell us.
3, 4, 5, my lord. All these are-
PW3, PW4 and PW5 are seizure witnesses. They are all officials.
all of it.
Okay. All officials. Then
PW9 is the Gaunbura, my lord.
PW9 is Gaunbura, who verified that you are the owner.
My lord. He issued a certificate on the dictation of the informant.
We'll see that whether on the
Definitely.
dictation, what is your cross-examination, that we'll have to
Yes.
see. PW9 is Gaunbura.
Yes.
And who will represent this site?
One Deepak Gupta, my lord. Advocate.
Name shown?
Yes.
DKD. Okay, fine. If name is shown, that's good.
Now you'll also kindly peruse the
Where
complete.
do you get this evidence?
Yes.
PW 9 in evidence is in
PW?
PW 9 mail. Gambura
PW 9. Where do you get that?
file A mail in the
Huh?
LCM. File
Have you
A.
flag marked? Like, yeah, please flag mark it. Find it out, flag mark it. The important evidences,
Yes.
including the first complaint or FIR, whatever. In the Railways Act. What is the standard of proof in a case under this? Beyond all reasonable doubt, all there is there any presumption, clause of presumption in the act? Then how can you say in the this is one. Second thing is that is there anything, any prescription under the act as regarding voluntary disclosure? Is there anything? So we'll have to address all this. Ready? At 2. But don't say that I need time in the midway. See, forget about them. Their name is shown that they are not there. What can we do? Huh? So two things that you are saying that yes, always prosecution is to prove beyond reasonable doubt. No doubt about that. But in certain special acts, there are some presumption. So moment prosecution establishes or discharges their burden or lays the foundation. Foundation is to be laid. You will have to rebut it. This is number one. Number two is that there is a provision under this act also as regards voluntary disclosure in presence of witnesses. Now, any judgments on that in view of subsequent determination regarding voluntary statement in NDPS Act, whether that proposition can be.
Mother's
Many things will come and go in this life. We'll have to finish this. Many things will come and go.
all these judgments I could not.
We'll try. We'll do our homework here sitting. But we cannot adjourn these cases.
As they it will be mal.
See, there are some serious implications in this case. Whatever way we pass this judgment, that will be binding upon many courts. There are some change in law so far relating to even NDPS Act. Isn't it? whether that proposition can be brought in, what are those provisions in under this act? Yes,
Also to be
forget about it. If somebody is not here, why we are bothered? If you would not have been here, we would have appointed an amicus where important things are necessary. In 125, we will not appoint amicus. But forget about him.
We'll do my.
We'll go through the record because we are concerned about the right of the accused. Therefore, if you are here, we'll hear you. If you are not there, we'll appoint an amicus where necessary. Even if it is revision, no problem on that. Forget about them.
If possible, ma'am,
Wednesday. Okay, Wednesday. But please come prepared because it will have a ramification. The way it is not that so and so has said so and so, it will not do that. Two things. One is you have to show that to give you an, and that too are in a revision, that the basic foundation was even not laid. We have passed a judgment day before yesterday, something like 45. Not 45. We have passed this in Assam betting and gambling, where presumption is required.
then my lord, since presumption is there, so my lord, guilt can be.
No, presumption is there, I understand, but foundation is to be laid.
Gambura says, my lord, he is dictated by the informant, my lord.
We do not know what Gaubara
Maybe
says, but
independent
you will have to show that the foundation is not laid. So what should be the foundation first? That we'll have to argue. That under these provisions of law, this is the foundation. In the NDPS case, you'll have the foundation is this is the position is there. If position is not true, forget about presumption and 35 and on.
Because in the act, my lord, there is cause of presumption.
We'll give first preference.
Wednesday, my lord,
Wednesday.
college.
Yes, Bhattakur, which are your methods? Today it's doubtful. 2011. All these are 2010. We'll immediately coming after, we'll take up this motion. Okay? That too will take up the motion and why this order 17. Then we'll go serially, all pending first preference.
Page 10, Lordship, the con.
Charge sheet has been filed. All for the scan copies, we'll see once again. Hello?
15 page.
Interim bill, how can we give you? Can appear, no problem on that. We have already passed in the earlier order.
380.
With a liberty petition to appear before the appellate and seek regular bail. That order is already there.
Yes,
No,
Lordship.
nothing doing that. Will not pay nothing more than that. We can call for the scan copies once again, see. That's all. Scan copies. Nothing more. Once weeks after scan copy reject, this will be in a difficult proposition. Why your time and again you are coming, we do not know. We have given you an option. Go there. We have asked them to consider as per law. They will consider, that's all. Once we reject after search sheet, you are in a difficult position.
Unless there is special reason,
Yes.
situation.
Can.
That to
scan
that
copy?
we are saying, if you call for the scan copy, we apply our mind, we'll take our decision. That's all.
Time Lordship may.
Oh no, we cannot pass. Already that is there. You are taking your risk. That's all. We'll call it.
I'm obliged.
Can after scan copy, give a date after scan copy. January. It will be in the January. Before immediately reopening, give a date. Huh? No. Second is reopening. The 2nd January.
What?
Obliged lodge.
17 for orders.
Kindly pass over the matter for time. It is in court number 15.
Who is your senior?
Vishwas, sir.
Okay, we'll to 2012. We are taking 2010 meters. Let us wait for some time.
Right.
Let if we'll go by seriate up. Order next.
Please, your lordship.
Okay.
Lordship, in this case, all Advocate Z. Kamar is not the list, but he's conducting.
So-
Is the file, lordship.
Don't forget about that.
Lordship grants 1 week. time.
Senior advocate should be briefed by juniors. Don't demean a position of a senior advocate that senior advocate lost his file.
Lordship,
Is it his position? Mr. Kamar's position has gone to that extent.
lordship, I did not.
Seniors are being briefed by junior. Junior says file is missed. That is a different issue.
Otherwise, lordship, if I am allowed to place on merit, lordship, I'll rely on two judgments.
Supreme Court judgment will come later on. First, we'll have to understand what are the facts and figures.
Lordship, fact is, I do not have the file in front of me, but the fact in a nutshell is that this is a criminal revision against concurrent finding.
If you don't
Uh,
have the file, why should you give an audience?
But otherwise, I have the file through the record, lordship.
Yes, tell us.
Criminal revision against
Hmm.
I was petitioner, the accused number 1, the petitioner was convicted under sections 7 and 16.
7 and
16. 7 read with offense, 16 is the punishment. Thereafter, a criminal appeal was preferred. We are before. Lordship, what has happened in the midst of proceedings is that the offense was committed under section 7 and 16. Thereafter, Food Safety and Standards Act came into picture.
Hmm.
The corresponding section now is section 52. Otherwise, if we take into consideration Article 20, Clause 1, ex post facto law, that should be applicable. But there are two judgments by the Honorable Supreme Court. Since the new punishments are only fine, no imprisonment, that benefit has been given to the accused of offenses under section 7 and 16. So I'm relying on those two judgments. Lordship, first judgment that I'm relying on is Trilok Chand versus State of Himachal Pradesh. This is a 2019 matter.
which paragraph?
The Lordship may only see paragraph 6. May I read the relevant portion, Lordship.
Yes.
We have considered the respective submissions in criminal appeal so and so. This court relied on a decision in T. Barai versus Henry. And it
So
was
what is
recommended-
the present prescription?
Present prescription, Lordship, is that the matters wherein the offense was under 7 and 16, now that benefit of the new legislation is being conferred on the accused
Understand,
persons.
your whole sum and substance argument is that when the offense was committed, it was offense under section 6 and 16.
7 and 16.
7 and
Lordship.
16. Now prescription, punishment prescribed were
Only fine.
at that point of time,
At that point of time, it was minimum 6 months up to 3
minimum
years,
6 months up to,
3 years.
and you have been convicted?
For 6 months.
No,
SI?
6 months, so
Yes,
6 months.
Lordship.
Therefore, your whole argument is that in view of amendment,
Lordship.
corresponding sections will be sections
52 of the
Food
FSSA Act.
FSSA Act.
Yes,
So in terms of 52,
Lordship.
the punishment prescribed is only fine.
Only fine.
And therefore, you are entitled to benefit of only fine.
Lordship, since
This is
similarly
decision,
situated.
and in this regard, you rely on the judgment of Honorable Apex Court in this case.
Yes.
This is your argument. So you are not on conviction, you are only on sentence.
If that is allowed by this honorable court, then.
Let us see that. What was the offense? Let us see the two sections and what was the offense alleged and where it is corresponding. And this judgment is basically relying on the principle laid down in some other cases.
Yes.
In the case of,
There's a more detailed judgment also. This is 2024.
in case of that judgment of T. Barai versus Henry Aho, isn't
Yes,
it?
Lordship. Yes,
So paragraph 22 is relied on.
yes, Lord.
So you want a similar benefit, that's all.
Yes, Lord.
Let us pass, for that we'll have to have satisfaction that these are the two same offenses. So was that books,
If you
Food
Lordship says
Adulteration Act and Food and
the
Safe.
FSSA Act.
So before you go to the judgment, that's why I'm saying must understand the facts. Law will come, we'll understand. And Food Adulteration Act. Are you having the books
Lordship, I have a digital copy.
for court? You be digital, but with at least you could have digitally transferred it to my assistant. Isn't it? When you are digital, you should be digital in true sense. We are not saying you should give us a book. You would have transferred it digitally. Isn't it?
Take care of it.
Food Adulteration Act.
Otherwise, Lordship, 7 is a broad section, but the offense that I am alleged against is that misbranding. So,
Therefore, we must understand what is the prosecution case. Then we'll understand what part of section 7 is you are convicted.
Lordship.
Then we'll have to see section 52, whether that comes under misbranding. If it comes under misbranding, and we'll have to give a conclusion, isn't it? So it is 1954 Act, isn't it?
Lordship.
Section 7.
7 is the offense, Lordship. 16 is the punishment.
We'll pass. Let us come to the offense. Okay, take down. Just will record the facts. Then we'll come to the conclusion. Heard, you are Mr.
Y. Kothari.
Y. Kothari, learned counsel for the petitioner. The present application under section 397/401, read with section 482 of the Code of Criminal Procedure 1973 is filed assailing judgment and order dated 7/1/2010 passed by learned subdivisional judicial magistrate number 2 within brackets Sodor Kamrup in case number 82C/1999, whereby the accused petitioner was convicted under section 7 of the Prevention of Food Adulteration Act 1954 within bracket hereinafter referred to as the Act 54, and he was sentenced to, he not he, petitioners were sentenced to undergo a simple imprisonment of 6 months is to pay a fine of rupees 10,000 only each, and in default to pay fine, comma, and in default to pay fine, comma, a simple imprisonment for another 1 month. The further challenge is and judgment and order dated 9/8/2010 passed by the learned session judge Kamrup Guwahati in criminal appeal number 13/2010, dismissing the appeal and upholding the conviction and conviction. Is that it? Same conviction. The learned counsel for the petitioner argues that relying on the judgment of the Honorable Apex Court in the case of Trilok Chand versus State of Himachal Pradesh, reported in 2020 10 SCC 763, argues that the petitioner was the sentence prescribed under section 7/16 of the Act 1954 at the relevant point of time when the alleged offense was committed was minimum 6 months of simple imprisonment. I mean minimum simple and fine,
Up to 3, a fine of minimum 1,000 rupees.
and fine of minimum 1,000 rupees. However, by virtue of enactment of the Prevention of Food Adulteration Act 1954, the corresponding sections, that is section 52 of the Act, the punishment prescribed is only fine, isn't it? Only fine.
Only fine.
But
But up to
punishment prescribed is only fine, and up to
3 lakhs.
rupees 3 lakhs. Up to rupees 3 lakhs. Now think over it, how much fine you will pay.
Yes, Lord.
At least half of the fine.
Lordship, otherwise minimum. For other defenses also that we had taken the benefit of 9. But for now, since there are these,
Not for now, either this or you are without brief or merit. Okay. And therefore, he submits that the all petitioners should also get benefit of the aforesaid principle of law laid down by the Honorable Apex Court.
Lordship, if Lordship may also consider the latest judgment, AK Sarkar versus State of.
We'll come to
This
that.
judgment has relied on Trilok Chand again, 2024 matter.
Then you write it referring to the judgment. See, we'll not unnecessarily quote many judgments. Upor jitu kolu referring to the judgment of the Honorable Apex Court in MS AK Sarkar and Company, another versus the State of West Bengal and others, reported in 2024 INSC 186. To consider the aforesaid submission, this court is to go through the complaint that is filed against the petition. Where is the complaint? Complaint is not annexed. LCR. Basic allegation, the complaint is that as per public analysis report dated 18/11/1988 on the seized vegetable oil, which was seized from the possession of the petitioners, is old refined vegetable oil comma rancid RANCID, and hence does not conform to the standard, and the sample is misbranded. Sample is misbranded.
Aspect, this was in the transit. So the accused number 3 was also convicted. The company that had sent the goods, that was convicted and they paid the fine. So they did not prefer the appeal. The appellants, the accused number 1 and 2 preferred the appeal. 2 has expired in the meanwhile.
Huh?
Accused number 1, Gaurav Devda, now is alive. The petitioner before this.
We'll come to that. We'll
Lordship.
later on just remind us. of it.
Lordship.
Full stop. Comma misbranded. Misbranded. Accordingly, the petitioners, two petitioners, along with the two petitioners, along with what is that cooperative?
National Cooperative Consumers Federation of India Limited.
National Cooperative Consumers Federation of India Limited were prosecuted. It is submitted by the learned counsel for the petitioner that though 3 of the accused, including accused number 3, that is National Cooperative Consumers Federation India Limited, were convicted. However, the accused number 3 did not prefer any appeal and paid the fine. So far relating to the accused number 1 and 2, who were from whose possession
Possession, otherwise in transit. It was
proof according to them it is your possession.
Lordship.
Transit is your case.
Lordship.
What is proof according to the trial court? From whose possession the misbranded materials were recovered? That is petitioner number 1 and 2 has preferred the present revision petition. It is submitted by the learned counsel for the petitioner that the petitioner number 1 had in the meantime expired on. Petitioner number 2 had in the meantime expired on. Then why you make a submission?
I think that report was called for, and
This is the difficulty. You are relying on what you think. And we'll have to decide on what is available. It is not expected from a young counsel like you. Forget about that, not necessary. Section 7. Section 7 under the Act 1954 prohibits the following. Prohibits any person sell or store or distribute any adulterated food, any misbranded food, any article of food for the sale of which a license is prescribed, except in accordance with conditions of the license, comma, any article or food, the sale of which is for the time being prohibited by prohibited, semicolon, any article or food in contravention of any other provision of the Act or any rule made thereunder. From the allegation in the complaint, as well as conviction of section 7 of the petitioner's herein is relatable to adulteration or misbranding, because they say this is not a human consumption. Is relatable to adulteration and misbranding. Full stop. Adulteration and misbranding. Where is that act? Oh. The aforesaid, no, big one. Aside. Full stop. Full stop. Subsequently, in the year 2006, the Food Safety and Standard Act 2006 was enacted, with an object to consolidate multiple laws and their enforcement and standard under one act. Accordingly, the earlier act was repealed. Huh? Sure? Sure or no? Then say us that. You take your seat, you are not at all prepared. File you might have lost, but books I think you have not lost.
From last moment.
Please, sorry, please take your seat. Also, in terms of section 97 of the Act 2006, the Act specified in second schedule were repealed, which includes Prevention of Food Adulteration Act 1954, Food Tax Act 1994. Subsection clause Roman 1 of subsection 1 of section 97 of the Act 2006 prescribes that such repeal shall not have effect to the previous operations. Subsection clause Roman 2 provides that such repeal shall not affect any right, privilege, obligation, or liability accrued, or incurred under any of the enactment or orders under repeal. That being the position, generally, the repeal of Act 1954 shall not have any effect on the conviction made or conviction made in the case in hand under the Act 1954. However, the Honorable Apex Court in Trilok Sand, referring to Trilok Sand, referring to the provisions, referring to the earlier judgment of the Honorable Apex Court in T. Barai versus Henry A. Ho and other, reported in 1983, 1 SCC 177, more particularly relying on paragraph 22 of the said judgment, concluded that since the amendment was beneficial to the accused person, it could be applied with respect to earlier cases as well, which are pending in the court. Wisdom. Pending in the court. Therefore, in the aforesaid backdrop, the learned counsel for the petitioner argues that the petitioner sentence can only be a fine under Section 52 of this Act. Section 52 of the Food Safety and Standard Act 2006, 52, na? 52. What is the penalty for adulteration? Come on. Section 51 prescribes for penalty for substandard food, which deals that any person which prescribes that any person who, whether by himself or by any other person on his behalf, manufactures for sale or stores or sells or distributes or imports any article of food for human consumption which is substandard shall be liable to penalty which may extend to 5 lakhs. In the case in hand, the complaint and the conviction is also relatable to an allegation which says that the aforesaid the material / food seized from the possession of the accused were not fit for human consumption. Therefore, such conviction may be relatable to Section 51 on one part. The other complaint is as regard misbranding, inasmuch as it is in the complaint on the basis of the expert opinion, it was alleged that the foods were misbranded. Full stop. Therefore, it can be relatable to Section 52 of the Act 2006, which prescribes that any person who, whether by himself or by any other person on his behalf, manufactures for sale or stores or sells or distributes or imports any article of food for human consumption which is misbranded, shall be liable to a penalty which may extend it to 3 lakhs rupees. Therefore, in the given context of the present case, this court is of the view that the determination made in Trilok Sand, Trilok Sand, Supra, and in AK Sarkar and Company within bracket Supra can be made applicable in the given case in view of the in the given facts of the present case. Accordingly, the revision petition stands allowed by allowed by interfering with the simple imprisonment of since 6 months and confining the sentence to the fine already directed to be paid. Revision petition stands allowed. Mr. Das, conviction remains not much. We'll give detailed things. Yes,
Deeply obliged, Lord.
it will come. Huh? Yes.
Yes, Mr. Lordship.
Mm.
Lordship, we could not communicate with the petitioner
You could not communicate with the petitioner.
as we're not aware of his whereabouts.
Okay. Let us try to communicate with the records of this case. Heart, you are? Huh?
Thank you, Kiba.
Learned Counsel for the petition. The present man appears for the private respondent. So Mr. Sharma is present. The present application is filed revision petition. It will give a section this and this criminal revision petition is filed assailing an order dated 19/6/2010 in CR case number 3437/2009. The aforesaid CR case number 3437/2009 was filed by the petitioner under section 138 of the Negotiable Instrument Act 1881. An averment was made in the complaint that there was 19 days delay in filing the complaint, and therefore a prayer for condonation of delay was made. In view of the aforesaid stand, the learned trial court issued a notice to the accused accused to appear and show cause as to why the said delay shall not be condoned. The accused appeared before the learned trial court below and filed his objection on 2/1/2010. After hearing both the after hearing both the learned counsel for the parties, the learned magistrate came to a conclusion that delay was not properly explained. Delay was not properly explained, inasmuch as though a stand was taken that accused was though an explanation was given that the complainant has failed. The learned magistrate concluded that though there are some explanation as regard delay for the reason of the complainant being unwell, however, there is no explanation of delay from 31/8/2009 till filing of the complaint on there is no explanation of delay of 11 days. Delay of 11 days. Okay. The objection of the accused that there was no separate application for condonation of delay was rejected by the learned magistrate on the basis of relying on the decision of the Honorable Apex Court in Dalmia Cement Bharat Limited versus Messrs Galaxy Traders and Agencies Limited, reported in AIR 2001 SC 676. The learned magistrate further concluded that the complainant received the intimation regarding the dishonor of Sheikh as disclosed in the complaint, as disclosed in the complaint, on 29/5/2009. 29/5/2009, full stop. 29/5, full stop. The period of 30 days under section 138 (B) expired on 28/6/2009. The period of 30 days, period of 30 days under section 138B to file a complaint, 138B expired on 28/6/2009, and therefore according to the learned magistrate, the notice of demand should have been made on or before 28/6/2009, but the same was made on 29/6/2009, which is clear from the complaint petition itself. According to the magistrate, such delay of 1 day in breach of the mandate of Section 138B of the NI Act cannot be condoned in terms of the Act. Cannot be condoned by the court. Full stop. NI Act. That's correct. 138B cannot be condoned. Here can be condoned filing. Negotiable Instrument Act. Section 138B of NI Act. Section 138 of the NI Act prescribe for penalties in case of dishonor of certain sex for insufficiency of funds in the accounts. Subject to however, Section 1 subsection B, no, Section 138 within bracket B. Proviso B to Section 138 prescribes that such provision of Section 138 CRPC, NI Act, shall have no application when the payee or holder in due course of the check makes a demand for payment of the said amount of money by giving a notice in writing to the drawer of the check within 30 days on the receipt of the information him from the bank regarding the return of the check as unpaid. Thus, the learned magistrate, on the basis of material available on record and as stated by the complainant, came to a definite conclusion that the check was dishonored on 29/5/2009 and the notice of demand was issued 29/6/2009. Thus, it was not within the prescribed period of 30 days. In the considered opinion of this court, when such materials were uncontroverted and there were specific statement by the complainant as regards date of receipt of information and the date of issue of the notice, the trial court has rightly dismissed the petition being barred under Section 138 within bracket B of the Negotiable Instrument Act. At 11 days we would have condoned, but this is your admitted position. Full stop. Inasmuch as this court has also perused the complaint petition complaint petition, which at paragraph specific in which at paragraph 5 it is specifically stated that the Drawers Bank, namely the State Bank of India, Bamuni Moidan, New Guwahati branch, hide their check returning memo dated 29/5/2009, intimated the petitioner as regards return of the check for insufficient funds. And at paragraph 6, it was specifically stated that the legal notice was issued on 29/6/2009. In view of this uncontroverted facts, and this court cannot term the decision of the learned magistrate either to be termed as having is illegal or erroneous. Accordingly, this petition stands dismissed. LCR be returned.
After reopening, he'll cut
Sorry.
hearing positive.
Sorry. This matter is pending 6/2010. An adjournment was sought for by the Learned Council, which this court is not inclined to grant. Accordingly, this court proposed and sought adjournment till Thursday for decision of this matter, inasmuch as this bench has been specially constituted to hear all pending matters. However, the Learned Council still insists on such prayer of adjournment. Accordingly, such prayer of adjournment till January 2025 stands rejected. Accordingly, Mr. Borthakur, as Borthakur, Learned Council is appointed as an amicus to assist this court in this regard. Relevant papers, including the evidence, be furnished to Mr. Borthakur by Friday, by today's Monday, by Wednesday next, and list this matter for hearing on Thursday. Item number? For what happened item
Similar
number?
prayer.
What is 4?
Thursday.
Same order. Give some other, this is revision. No? Give some other council as amicus. Give some name of other council as amicus paper. Yes.
Only code number 19.
What is this? Will till your senior comes?
Lordship, judgment and order dated Lordship 14/8/2006 Lordship.
LCR is there? Hmm? $363. What is 363? What is 363? A.
360 is punishment for kidnapping, man. You know, kindly peruse the order dated 4/2/2020, my lord. First order, my lord. My lord.
Record, LCR,
No, my lord. Order of this court.
4/2.
4/2/2020, my lord.
No, that LCR has come.
So, my LCR, in the LCR, only appellate part is there, my lord. The LCR court below record. That's why that order was given, my lord. LCR only appellate court order part is there.
Okay, registry is to furnish a report. Any report up to registry to furnish a report. In terms of this court. In terms of this court's order dated 4/2/2020. Okay, that deposition part is
My
not
lord, that
there.
is not there. Only appellate court judgment and order, and court below order judgment is there.
And list this matter again on next week, give a date. 19th.
I'm praying for, I think, only one day. But you
Why?
do not look at our file.
No, locate our value, go through here and argue.
Yes, I have seen.
If we start giving time to locate files, it will be difficult. What is the case?
Lordship appeared in an examination on behalf of Scott, and he was
What is the punishment?
punishment 1 year punishment.
1 year. What is the
Presently-
materials against you?
Presently, he is as a practicing advocate.
Huh?
And incident occurred in the year 1996. Papers were not sent for
What is according to you, what are the grounds we should interfere? Summary.
if
What is required to be considered and what are not considered? No, what are the material aspects in your case? According to you, these are the facts in this background. In short, why should we exercise our power in interfering with the judgment?
the present case, Lordship, that was law the prior that was not exhibited, Lord.
Okay.
That says, Lordship, no name was there, no roll number was there. Therefore, that is relevant, Lordship. Till point of time. So the admit cards which were seized, Lordship, not sent. Person
So
has
according to you, what are those evidences on the basis of which you have been convicted, which are not material?
Your Lordship, that confessional statement going to be confessional statement by the learned court was not sent to FSL to
Confessional statement in what form?
Lordship, that after apprehension by the principal, he written a letter that
So that documents were not exhibited.
exhibited, but that was not sent to.
Did you have any suggestion that it was not written by me? Now at this stage is saying will not do. You will have to whether you have disputed that document. They say that this is the confession you made before the principal.
In fact, Lordship, PW3 says, Lordship, that though that extrajudicial confession, that suggestion is that
Extrajudicial was made in before
that is
police.
treated to be as extrajudicial confession.
What is difficult in doing that? You know everything.
Point out clearly before your Lordship that
You go through it.
Only that I have to point out before your lordship that this is the line.
You go through it. File you will recover the file that we cannot wait. As simple as that. And it is necessary to have this kind of files, not to have any interest. Sometimes somebody might have cleaned the file and thrown it out.
Was there in our chamber.
Tomorrow is a difficult day. Nobody has seen tomorrow. Day after tomorrow, how many meters? See, look at her face. Will not take up this later on. We'll first finish up by this is 2010 and 11. Day after tomorrow. But you will have to have your either file and you mark it here. Mr. Das,
I will not seek for it.
don't seek for. Yes. Day after tomorrow. Meters, you know. This is item. That's 200 rupees fine.
For Miller.
Many sections, but there is a land, it's a boundary dispute. Marpit was there. Considering all above, only 200 rupees fine on each count. Sentence to fine 200 on each count. In default, simple imprisonment.
So we are not there. But
Hmm?
complaint case perhaps.
No,
How
it's a GR case.
only private parties are shown. Miller. We are
No,
not shown.
ultimately, there was an addition of state of Assam.
Acha.
It is an appeal or revision.
Revision.
Where is the judgment of the appellate court?
Perhaps appeal doesn't lie, Miller.
Hmm?
Maybe if only 200 rupees.
200. Oh,
no
that's
appeal
why
is
there is
provided,
no
Miller.
appeal.
Up to 300 perhaps.
Up to
Appeal doesn't
300.
lie.
It was filed by, it is against Equitel. If you say extend to 2 years, it may extend to 2 years, 2 years, or fine, or with both. Then it can be fine, only fine also. Only fine also. Only see 144, 447, 323, 324, 427. Any minimum period is there at that relevant point of time. Because there are some amendments.
Right.
The occurrence took place 5/11/2002. Kindly see, these are 147.
147. Yes. Up to 2 years or with fine or with both.
So it can be fine only also.
Fine only, yes.
And other section are 447.
447. Working house trespass, I think.
There's not even a case for conviction. They are happy with 200 fine, that's why.
Yes, punishment for criminal trespass. This may extend to 500 rupees.
Okay, only
For a
fine.
term which may extend to 3 months, maximum 3
Maximum
months.
3 months. So
With
there is
fine.
no minimum prescription.
No, my lord. Maximum.
So 0 may be also there. Then 323, 324, 427.
427.
323 and 324.
Mischief by causing damage to the amount 50 rupees. This. Yes. Maximum.
No minimum.
Punishment of either discipline for a term which may extend to 2 years or with fine or with both.
Okay. Then
427.
323 and 324.
Three. for a term which may extend to 1 year, or with fine which may extend to 1,000 rupees, or with both.
No minimum.
Minimum is the
Then 324.
324% Bihar Foreign the recognition is hard by reason. Punished with imprisonment either direction for which may extend to 3 years, or with fine, or with both.
Hard. None appears for the petitioner and court. The present application is filed assailing judgment and order dated 14/5/2010 passed by the learned Chief Judicial Magistrate Kasar Silchar in GR case number 3059 of 2002. 2002. The present petition is filed by the informant in GR case number 3059/2002 corresponding to Silsar PS case number 1515 of 2002 being aggrieved by judgment and order dated 14/5/2010 by the sentence, not judgment, by the sentence passed under judgment and order dated 14/5/2010 by the learned Chief Judicial Magistrate Kasar Silchar in GR case number 3059 of 2002, whereby and whereunder while convicting the accused under section 147/447/323/324/336 IPC, while convicting sentence the accused person to pay a fine of rupees 200 in each count. According, none appears for the petitioner to support his case. However, following grounds are taken while challenging the aforesaid judgment. Page 7, A, B, C, D, E. Okay. Peruse the judgment. The learned trial court, while while considering the sentence, the learned trial court taking into account all the ordeals that the accused person had gone through due to protracted trial that lasted for long period, coupled with the siege and nature of injuries, and the fact that all this happens due to adamant attitude displayed by the prosecution side by encroaching a certain portion of public part sentence to pay only fine and conclude that same shall meet the ends of justice fairly and squarely. In the considered opinion of this court, in the given facts of the said case, more particularly when the matter involved a dispute over a plot of land / public road, this court is of the view that such consideration of the learned trial court cannot be termed as having any patent defect or illegality, patent defect of fact or law. Accordingly, this court is not inclined to exercise its revisional power to interfere with such a well-reasoned judgment. Accordingly, revision petition stands dismissed. Yes, next case. Yes,
My lord, in this case, RKD Chaudhary will appear in this case, my lord.
where is he? Why RKD Chaudhary?
CRPF,
Central government. CRPF.
Under
CRPF Act. It was
CRPF
convicted under
Act.
CRPF Act.
tried by
Tried by the commandant who has the real power under section
okay,
60.
what if he's not there, not there?
He's coming.
First of all, is he ready?
His junior informed us that he will coming, my lord.
He'll do the case.
He will do that.
Okay, what is the your fundamental thing?
Hello, the petitioner was tried in a day. He was convicted for 1 day, 1 day imprisonment, and after next order after 5 minutes, he was dismissed from service. So against that conviction, he has prepared an appeal before the session judge Dibrugarh
Appeal.
dismissed the appeal,
Ah.
uphholding the conviction. So, my lord, the law point is that under Rule 36, it has given empower this year under the CRPF Act that they will follow the criminal procedure code. My case is that not at all. Their
There is
allegation was
no-
different. Allegation was different. Evidence was different.
Okay, let us see what is the procedure prescribed under CRPF Act. This is item number
13.
13.
I have quoted section 16 at page 9 of my petition.
Page 9. What happened to his dismissal?
From service.
No
And
writ
it is
petition.
out of livelihood. Where is he now? And so, my lord, under
Let
section.
us not endeavor to that.
No, no,
Then, okay.
I'm not.
Yeah, no,
relying-
I understand.
I'm
That's
just
why I'm saying. Let us not
since you're
endeavor
aware
to
of what happened
Yeah.
after his dismissal, whether he has
We
challenged.
presume that he is alive, his lawyer is here,
Yes, yes. ma'am.
materials
Yes,
are
ma'am.
there, we'll decide.
Yes, ma'am.
That's all. Otherwise, these matters will never end. Which paragraph?
Page 9. Page 9, paragraph 18, I have quoted section 16. That from the commandant derives the power, my lord. Power and duties conferable and imposed. The central government may by general or special order confer or impose upon any member of the force any of the powers or duties conferred.
Let's verify whether he will argue. If not, we'll not midway. Huh? Just wait, Mr.
Yes,
Singh,
yes.
just wait for some time. Yes, next case.
My lord, this is a conviction for 6 months and the penalty of fine of rupees 1,000 in default of my lord. Another penalty under section 7 and 16 of the Food Administration Act 1954.
Hmm.
So my lord, the new act has come, my lord.
Ah.
The 51 and section 50 and 51, my lord. The Trilukson case, my lord, that was also reflected. The entire, my lord, offensive substandard selling of substandard that has been reduced to only penalty fine, my lord.
You are
But I-
happy with, you are happy with that?
My lord, not only happy with that, but the thing is that when so far my case is there, my lord, if there is
If you are happy with that, we have already passed the judgment today itself,
my lord,
relying on Triloxan and all, saying that this is the facts, it is relatable and only fine.
But I prayed, my lord, that may be acquitted honorably because my
Then you argue, but you are taking a risk. Then we may not even convert the fine.
Well, a simple thing, my lord, here.
No. See, Mr. Mohanto, if you want to argue on merit, please argue.
My lord,
That's all.
my argument, my lord,
No, please
Taking-
first let us understand. You are arguing on merit.
my lord, I'm saying, my lord, merit as well as your lordship.
So
are
therefore,
defending
you
your-
argue on merit.
My lord, the facts is this, my lord. That the case of the my lord, long pending case in 19, my lord, this is 94 case, my lord. And in that case, well, a conviction was that was given by the trial court, that was upheld by the appellate court in 2002. Well, the offense was that I have selling, my lord, the iodized salt that is substandard by 2 point, my lord, 2.03, my lord, percent of iodized was salt in percentage as per the part of the per million, my lord. So that is standard should be 15 parts. So there is a deficiency only 2.9, 2.3 parts, my lord.
Mm.
So, my lord, our ground was that, my lord, he took the sample that is on, my lord, the sample was taken on, my lord.
Yes, Mr.
20 to
Akeri Chaudhary, are you
992.
ready today? But some other day will not go beyond the next week.
Because though I have gone through lordship hectic, I have almost.
No, that's why we can accommodate you. We know you are busy taking many methods. But here limited issue is the CRPC is required to be prescribed. He has been convicted within 1 day. If he has not been given any chance to defend himself, then it will go. See, even if it is CRPC is not applicable, you are convicting a person. He must have been given some time to defend himself, cross-examine at least the witnesses. If that is not there, it will go.
I take the cue, lordship.
Where we may not go into whether he has done or not, because if his right to defend is vitiated, even nowadays 313 statements are, if not properly put, defense is not known, then also it vitiates as per Supreme Court judgment. And in case of when you have convicted him according to him within a day, this will be a difficult proposition.
Lordship, I have the records, I will place.
Okay, if you say that no, this is even if it is permissible and rightly, then procedure is followed.
Even otherwise, lordship, it was a conviction and sentence only for that day.
Maybe,
No.
but that is having a ramification. He has lost his job.
He has lost his job. He was dismissed from service, but later on it was converted. He is getting his full pension. It was converted.
Okay, fine, but conviction remains.
Yes.
As-
That your lordship will say.
Conviction remains. We'll not go to that part. That I told him. We'll not go that. See, he is now have the information. Your client is happy having the pension. Forget about the conviction.
Compulsory retirement with full pension.
So therefore, he is not contacting.
He is not contacting.
Yes, that is the reason. Otherwise, he would have contacted.
Yes. And it is a-
Everything is relatable to a situation,
Yes.
isn't it?
Yeah.
Either somebody is happy, my sentence is stayed, I am happy. Forget about that. Lawyer is unhappy, no material instruction, so I will not come and do that. But we cannot do either.
I have accepted the.
No, that is the good thing. Once you have accepted the brief, at least come whether you are having clients relation or. In fact, I was thinking of whether this amounts to a misconduct. We will not decide it to be misconduct, but we will definitely refer it to Bar Council, saying that the council's name is in the Wakalatnama, name is reflected, not appearing 2010. So, as prima facie view is that this is a misconduct, so send this matter to Bar Council, will decide on its own merit. That we are thinking of. Let us see of New Year. If 1 and 2 goes, then everybody will be here.
Oh, that's fine.
16th,
That's
Minus 16 and 17, I will be out of station. 18 mile.
18th. 18th?
In fact, lordship, just off the records. Similar case, BSF, a person was, BSF, what happens? If there is a force court, the person has to be arrested, kept detained after the. And the force, he was arrested, kept detained, force court convened. He was given 3 punishments. But that again has to be confirmed by the confirming authority says, no. You cannot give 3 punishments. You'll have to give 1 commensurate with the offense. Came back, force court said, no, dismissal from service. And interesting, the writ petition is filed on the ground that he has been punished 5 times for the same offense. Because arrest and kept detention is one,
Fine.
punishments
Yeah.
given by the force
Four.
court is 4,
Yeah.
again dismissal is 5.
Five. Okay, yes, Mohanto.
In this case, my lord, the sample that was alleged to be taken on my lord 20 to 994.
Mm.
And the my lord examination that was my lord came on 21/10/1994.
Mm.
And my lord the lodging of complaint that is on the basis of the note of the my lord inspector, food safety inspector, that was on my lord 24/11/1994. So our ground was that they at the time of the my lord the taking the sample, from that to my lord the till the examination was done.
Mm.
There might be my lord some marginal difference. There may my lord some sort of my lord but trifling or my lord the marginal difference of the 2.03 my lord the differences parts, and the my lord the some my lord the there is some defects of accuracy also my lord. So far the examination is done, some evaporation and the proper sealing, everything is concerned. So-
Did you have all these suggestions?
My lord, yes, I have put all the suggestions. My defense was that, my lord.
That was your
That
defense.
was my defense. But that,
How
was,
the court dealt with that?
but that was not considered, my lord, and the things, my lord, the lordship, the defense that the independent witness also, they, in light of the another judgment, my lord, it is saying that it is a mandatory, not a, my lord, statutory. So that is another.
Which that
That regarding the independent witness are not there. So he, person who brought with him.
independent witness, what my understanding is that independent witness, when available, should be taken for the sanctity of the seizure. But when it is not available, this will not vitiate the entire proceeding for want of
That is
independent.
I also agree, my lord, but
That
not
is
entirely
the
so.
law. In fact,
And
I think the judgment, please keep it. This will
Right.
come in many cases. That repetition, Oil India and Bora Service. What that judgment? That in that judgment, I have dealt with this provision of law.
with another.
Oh, it was a repetition.
Yes, yes, my lord. And the
Those
second.
judgments are quoted in that. We will not go to the independent witness at this stage
At this
after
stage,
concurrent
no,
finding. Now
but-
tell us what is the major
The
defects?
defense was that the accused number 2, he was not immediately, my lord.
What is the offenses you have been?
offense, my lord? The shortage of iodine, my lord.
No,
iodine.
forget about the facts. What
Section
is
7, 6,
according to the
6 and my lord, 7 and 16.
section
7 and 16, my lord.
7 and 16?
Yes, my lord.
16 is the punishment.
Punishment, my lord.
7, which part? There are
7, my
three
lord,
parts
this
of the 7.
And the selling of substance.
One is any adulterated food.
Not actually adulterated definition, my lord, substance are also come. I have gone
Then
through adulterated, but the adulteration is converted is substandard. So
Okay.
our defense was.
then misbranded. Others will not come. License,
Yes, everything,
article of
nothing,
food which
nothing.
are to be prohibited will not come. So
No.
accordingly, in your case, there is no misbranding also in your case.
Nothing.
Nothing. So it will be an adulterated food.
As per their definition, I have gone through the definition also.
Hmm.
Substandard also covered under.
Under
NITC.
adulteration.
But the defense was that that is no, I am not a producer, I am not a manufacturer.
Now,
I have purchased the things from a other farm, my lord. I have named the farm,
Hmm.
but the that was the my lord 50 kgs, my lord, total bags containing salt, iodized salt. So out of which, my lord, I am selling some my lord, as per the
let us
requirements.
see where is the allegation. Complaint.
And that was not annexed, my lord, here.
Hmm.
But the judgment also. my lord. Lordship will come with the first judgment, that is at page.
Who are the star witnesses?
Is a food inspector, my lord.
You are Gopi.
Gopi Agarwal, my lord.
And who is the other?
Other is my father, but interestingly, father was brought, my lord, after taking all the evidence by the my lord court at the behest of the court, my lord. Not before that. And in my defense, I have specifically stated, well, I have purchased the from a farm named, my lord, Subidha. Subidha, that is the original seller of, my lord, the bag of iodine salt.
What is your cross examination?
Point number 6, my lord, civil gauge
Just a minute.
is 29, my lord.
Yes.
PW2 and 3 is the person who accompanied the my lord PW1. These are the evidence, my lord. Public analysis was not brought before the court.
Public analysis was not there. That analysis was not proof.
Not brought. But
Any prescription for sealing the sample?
no, my lord, they said that they have purchased, but there is no any purchase, my lord.
No. Forget about the purchase.
The form was
When you take a sample and take the sample to the laboratory
three part.
analyst,
Yes.
okay. Now, what is the prescription as regards sealing and seizure? Any prescription for sealing it?
Prescription, my lord, this is a rules are there, my lord.
That is a rule.
Yes, my lord.
After purchasing from the
Uh,
shop,
uh.
they seal it instantly. In
Instant
presence of
in
witness.
presence of witnesses, how it is to be sealed?
Seal that is provided in the rules, my lord.
What is that prescription? I want to know.
Here, my lord, they are saying, my lord, the section 14, my lord, probably.
Tell us what is the prescription, how it is to be sealed?
It is a clean paper, my lord. They have to, my lord, they seal the all the, my lord, sample they have collected, my lord.
They say we have taken it 3
Three
containers.
contents.
Containers. There was an
That should be properly tight and sealed.
where is that? That is what
Yes,
I
my
want
lord,
to
that
know.
is-
Because this is your defense.
Yes,
You
ma'am.
have not properly
Yes,
tied and done in
If the
adhesive and all. Where is the prescription to give adhesive?
container itself was not washed properly. These things.
These-
are-
these
Secondly, in this section, my lord, section 14 of this, my lord, rule 14 also.
What it says?
It is saying that the manner of sending sample for analysis.
See, your whole defense cases,
Yes,
forget about others. 3
Yes,
part.
Yes, yes.
Your first part is that no independent witness, your defense case. Second is that sealing was not proper and there was nothing to suggest in between when it was sent to the analyst and how it was seized, what it was in between. This is your case.
Yes, madam.
Therefore, before that, I want to know the prescription.
Yes.
Then only we'll go to your defense
Yes.
and dates.
Rule is there, madam.
What is that rule?
Part 5, my lord, is sealing, then, my lord, fastening and the dispatching of the sample, my lord.
Hmm.
The rule 14, manner of the sending sample for analysis. Sample of food for the purpose of the analysis shall be taken in a clean, dry bottle or jar or on other suitable container which shall be closed sufficiently tight to prevent the leakage, evaporation, or in case of a dry of substance, entrance and moisture of shall be carefully sealed.
Now your whole case is that I did not fix your suggestion was that he did not fix the lids of the 3 containers with any
Yes.
adhesive or wax.
Yes.
Where is a prescription of adhesive and wax? That is
Adhesive
what
is-
I am asking.
Adhesive is not there, but properly set to be tight. There,
So there, see, your whole case should be based on you have said adhesive and wax.
Yeah.
It is not a fact that I do not pack and seal containers in which samples were kept as per Rule 16 of the PFA. What is Rule 16?
Rule 16, my lord, saying the manner of the packing and the sealing for the sample.
Hmm.
All sample of the food sent for the analysis shall be packed, fastened, and sealed in the following manner, namely, the stopper shall be first be carefully fastened as to the prevent leakage of the container to the
Hmm.
transrit. The bottle, jar, and other containers shall be completely wrapped in fairly strong, thick paper. The ends of the paper shall be nearly folded and in the fixed by the means of gum and other adhesive.
See, Mr. Mohanto, difficulty is here. Your cross-examination. What he affirmed. I bought 3 plastic containers from the Office of Joint Director Health Services for collecting sample. This is affirmed by you in cross-examination. Prior to putting the samples in 3 containers, I cleaned the container with cloth in presence of vendor. This is your cross-examination.
That is their case.
Then,
Is they are saying, my lord.
Cross examination.
in cross-examination,
That is true, my lord. That is true.
Not in SIF, in that's why I've said, let us see your cross-examination. Then you say, your suggestion was that you have cleaned it with chemical.
Yes.
Therefore, report is different. He said, no, I did not clean the containers with any chemical.
And that was not wrapped with money.
It is not a fact that I did not pay conceal. How do you prove that?
No, my lord,
All these
but-
things should have been said in the examination in chief by the
but
complainant.
one thing is there, my lord, the examination that was. done
Merit,
where-
it will be difficult.
My lord, one thing, my lord, lordship, kindly bear with, my lord. Date of the my lord, collection of the sample and the transitment to the my lord, analysis and the coming of the report and then my lord, the filing of the my lord, complaint. So there is a gap of more than 1 month in.
Where is that in your defense case? Any suggestion? See, please remind, let us remind ourselves that we are in a revisional jurisdiction,
Yes, I-
not in appellate.
I am.
Appellate we can go through. Where is your case that I have read it therefore? Your defense
My
case.
lord, this, my lord, one part is that, my lord.
See, you will have to give with a witness a chance as regards your defense so that he can reply. Say, suppose in a manner, it was your case that you have not cleaned it with
Yes.
cloth. He said that you have not cleaned it.
Yes.
He said that I have cleaned it.
That is-
So you'll have to give him a chance that it was in such and such that you may not say in so many terms that you have not sent. You may say that it is date is so and so, so and so, date is so and so, so and so. You have not
But,
kept in this proper custody.
One thing is there, my lord, that part is okay, my lord, I am also not disputing, but whenever the receiver, the analysis, my lord, how he received, my lord, in what condition he received, that was not proved before the court, my lord. Because analysis has not come before the court to say this thing, my lord, only report is not enough. Because there is a gap, I am taking the defense from the very beginning.
That can be a vital issue.
That is omission, serious omission, my lord.
Serious
That-
omission.
Because that is the basic foundation of the case.
Of the case. If
Whether-
he is not here, his report is not even his.
He has not proved, not duly proved. my lord.
Because they could have examined that you have did not receive in the sample in a proper manner. He could not. So that is a fatal to the prosecution case.
কোনে exhibit করছে এইটো analysis report টো
হেৰিয়ে কৰিছে, PW1.
মানে complainant এ। He at this any other officer might have been called if he was not there.
There,
at the
anybody.
time.
That
Anybody of
at least
that office.
authorize that this is the I know
How
the
the complainant can prove that experts report.
because in these cases expert's opinion is vital.
Yes, that is the foundation of the
Foundation
case.
that this is the adulterated. Adulteration will come from the analysis report. Analyst is not here.
At the first time I encouraged him.
Also, my lord, this is not my manufacturer, not my end product.
Oh, Mr.
My lord,
Mohan,
no,
why
one
are you
thing,
going
one
to
thing.
that?
This is an open bag, my lord. This is a 50 kg of bag from which I am my lord, giving the all the.
Mr.
That
Mohan,
is
we
why-
are not in a writ petition.
No,
We are
open
in a
bag, that is why
revisional
he is
jurisdiction
prosecuting.
after concurrent findings.
I,
You can say yes, non-examination of the
Yes.
analyst is a
Yes.
patent defect of fact and relying, ignoring such fact and holding that it was a adulteration is a patent defect by the court. That should be your argument in
that
two
is-
lines. First part, you are saying what not.
No, well, this is my argument. This is the first part. This is all right, my lord. But even then, my lord, what if, my lord, my.
I will not write for
defense
the,
was that-
I will not write for the sake of writing that these are the methods I have rejected it. If I want to allow you on one point, why should I waste my time doing that?
That is up to you, lord. See, but even then.
No,
my
no,
lord,
not
right
up
say-
to, up to. We need the cooperation from everybody
yes.
to close
No,
this
this is the
methods.
case. I did not agree that this is not the things, my lord. I agree with the things, my lord.
So therefore, and we are in a revisional jurisdiction.
Yes, my lord.
That will remind ourselves and will not hesitate to interfere with concurrent findings
Yes, I
when
also-
there is a patent defect. This
Yes,
is a
I am-
defect.
I was very much careful before that I have. Lordship, I.
Give a judgment. Give a judgment saying that this is, if not examined, it is fatal. To shortcut the things.
And my lord, I have to, my lord, find out that some judgment. Today I am not cope with that judgment, my lord. But from my knowledge, but I am
Withholding
saying,
of witness.
prosecution witness, the fatal witness, but it is a lot of judgments are there, my lord, but right now I am not remembering one of these things.
Food adulteration, food adulteration. Food analyst report is under which section? What is section 13?
Power of the food inspector to deal with these criteria of the disease.
Section 13 of the 1954 Act.
Yes, my lord. Disease of food, my lord. Is 9A, my lord, it is written. Sending of the sample by the local health authority. Local health authorities shall within a period of the 7 days of the receipt of the requisition for this second part of the sample from the public analysis. Public analysis, my lord. It shall be the duty of the food inspector to inspect the peculiar may be prosecuted by
You did not have any cross-examination on that point,
all
section
that time,
13.
no cross-examination.
Nothing is there.
Well, then my clearly with the party 50 and 50 and
Nothing
you
is
have-
there. See, to give you a handle, there must be some base. That
That is-
food
that is-
analyst report is a copy is to be given to you.
and
Isn't
there
it?
is- And there is a procedure.
A
my lord.
copy is still given to you. That is a vital, valuable right to object at that stage.
For
So
further-
if that is not availed by you, there is no defense that no copy was given or I have not received any copies. And there are some kind of a presumption under this
And
act.
my lord, one thing also, there are three parts of the sample. That one part is after that and second part.
Forget about that.
So my lord,
It will-
my prayer, my lord, as per the new, my lord, act for the amendment, 50 and 51, my lord.
50
Because
and
it has,
50 and who
that has
took-
been, my
who
lord,
took
converted
that
to a fine
judgment?
penalty only.
Who took that dictation? Not
Seven, item taken is 7, my lord, I think.
item 7.
50, his
Huh?
case will come, no,
Same
51, I think.
This is 51. Write it down.
Other-
Only other was
other one 52.
51 and 52 both.
Both.
Here only 51. I'll just dictate the first part. That much.
87.
No cross-examination. You have
This
been.
case is not originally belongs to my lord.
No, no,
That's why
that
it
is not an issue.
collected.
It sometimes happens. We are not blaming anybody. We are not blaming anybody. It so happens. This was the vital issue. That's why that section 13 is provision are there, so that you get a chance. Subsequently, you may not be able to raise such objection. That's why the food analyst is not examined. Let us not go to details to those provisions.
That's fine.
In this case, at least, in appropriate case, we'll deal with. Disposed of.
Pass,
What was the item? 7.
Seven.
Similar to 7.
Seven.
Huh?
I think the 7
Nah.
case was.
Here only difference in that case, section 51 and 52, here only section 51. And first paragraph, I'll dictate that regarding complaint. Yes, next case.
Pass.
Three, Nikki. See, here, my lord, I have further checked the records.
Hmm.
Here, in the FIR, my lord, there were 19 accused.
Hmm.
Now, only 7 accused were sent up for trial,
Trial.
and others were not. And out of these 7 accused, only the present petitioner is convicted,
Convicted.
others are acquitted.
Acquitted. What is
Now,
what
so
is the
far
difference
injury-
between him and others?
My lord.
What is the difference?
My lord, from evidence it appears he has not inflicted the injuries.
Okay.
So all the witnesses have, my lord, named him.
Pinpointed him.
Yes, yes.
What
Others
is the-
were-
What
others
is
were-
the medical evidence?
Medical evidence, my lord, exhibit 2
Hmm.
is the medical evidence for Abdul Malik, who was stabbed
Hmm.
in the abdomen. And exhibit 3 is the Amir Hussain, my lord, he was hit in his head, my lord, by iron rod.
And all these witnesses pinpointed him.
My lord, yes.
Only one.
PW,
PW4 is.
no, the PW1 is informant, my lord, he is reported witness, brother of the my lord
He
victims,
reported, forget about him.
reported witness.
The
Your-
injured victim and the eyewitness, tell us about that.
Yes, the eyewitness PW4,
And who are the injured?
injured PW2 and 3.
What both of them, they name
Yes,
him?
yes, yes.
Both of them. Okay,
Yes.
we'll come to you.
Yes.
Just let us understand. So both of them named him inflicting the injury.
Yeah.
Now PW4 is an witness. How he is related to both of these
My
parties?
lord, he has some relationship.
Any doubt created that he is interested witness
no,
in
no, no,
defense?
no such contradiction.
No, okay. No. Any defense taken that he is an interested witness, he is relative to so and so, any defense?
My lord, that such details I have not gone into. my lord.
Okay,
I
this
do
will
not
be
have
the
time.
fundamental
But
issue.
yes.
Okay.
But
Then
otherwise, he
he's-
has some relationship.
Okay, so he
Uncle or something like
witnessed
that.
this accused,
My lord, yes.
he witnessed this
Yes,
accused
yes.
and medical corroborates.
So he, PW4 fully corroborates PW2 and 3.
2 and 3.
victims.
And what about the doctor?
Doctor, yes, he has examined, my lord, he has proved the medical evidence.
Medical
report,
evidence proved.
Medical report.
Okay, yes, Mr. Vishwas.
Right. Got to be disposed of, my lord, because
Not disposable. You
there
just
are-
understood the PP's version. Will hear you.
my lord, there are.
See, according to me, with my limited knowledge of criminal law, what I understand is in a case of this hard 325, 326, 323, if the injured victim's testimony is trustworthy, not implicated you falsely, corroborated by the medical evidence and some eyewitnesses, nothing more is required.
Yes, my lord,
If you want to, then you will have to say that this, on the basis of this, he was not at all trustworthy. So therefore, these witnesses could not have been believed. This can be one. But again, he has been corroborated, immediately sent to medical, fresh blood oozing, all these kinds of things are there. Subject to what you say.
fact, today, two old appeals where I am appearing were fixed, my lord. One is that item number, Gulu Kathar. Item 17 and this. In fact, I prepared 17. This was a bit surprise to me, my lord, because this is also.
No, in
but-
this
but that-
court, I will give you a free advice to prepare the cases listed.
No, my lord. my
We'll
lord,
try to finish it off.
Yes, my lord, absolutely. I'll, because this is, my lord, because these are old pending matters. My lord, what I have understood, PW4, my lord, he is the only eyewitness. This incident took place in a football match. So, my lord, there were a lot of other independent witnesses. No attempt is made to examine a single independent witness.
Okay.
When it comes to PW4 kindly appreciate, he's the nephew.
Interested witness.
Interested witness.
Okay, forget, discard his
With
evidence.
PW4. And my lord, it is hard with a weapon.
Hmm.
Weapon is not
Recovered.
not
Okay.
recovered. Now, my lord, they
Please, we'll hear you because this is a case of apparently convicted for
1 year.
1 year. So you will have to satisfy what I could understand from you that when suppose in a situation when injured victims' testimonies are trustworthy, unsecond, cannot be discarded, the recovery of weapon is necessary, or that independent witnesses corroboration is necessary. Suppose we discard everything.
No, my lord, if a eyewitness is trustworthy,
Hmm.
then whatever little I have
Trustworthy and injured witness, not general witness, injured witness. His standard is a little bit been given higher pedestal.
now, my lord, these are two categories of witnesses. One is a injured witness.
Hmm.
The evidence of injured witness, as your lordship says, is regarded at a higher pedestal because the injury speaks
Hmm.
about his presence in
Hmm.
the spot. The injury speaks about that he was present. That is the philosophy behind why the injured witness is considered as a trustworthy. Now, my lord, in a case where an injured witness he implicates 17 or 19 in an FIR, no evidence is found
Yes,
again
that
more
can,
than
that
50%.
can be a good ground.
No evidence is found against more than 50%. Charge sheet, police finds evidence against 7%. Court finds evidence against 1%. So this very nature of implicating
Needs a
random
corroboration.
corroboration.
Okay,
sorted.
accepted.
This is one.
Hmm.
Second, now in a case where, because there was admittedly a clash in a football match. Now, my lord, there will be a tendency to implicate the people from the other camp. Now, my lord, here there is the eyewitness as reveals from the evidence is PW4. Subject to, I have not read the entire evidence. Honestly speaking, I don't have those copies, but since PP have read, I take him by PW4. But what I gather from the record, my lord, PW4 is the nephew.
Hmm.
Number one. Number two, the other eyewitness PW2. PW2 and PW4 are giving contradictory statement. There is, though the learned PP has submitted, it corroborates, but PW2 implicates somebody
Okay.
else.
Okay, so there is eyewitnesses
are
testimony,
different.
and their testimony is different.
Different. This is one. Second, now in such a case, my lord, there should be some link evidence. Now the link, my lord, the injury will per se not implicate a person. the injuries which will have to be connected.
Yes,
Now, the
of course.
connecting evidence is the weapon and forensic analysis of the fingerprints. That's the connection between the accused and this. That is, my lord, what I understand, my lord.
Mm.
So this is how, my lord, your lordship will have to.
When?
After tomorrow. In the meantime, my lord, item 17, I am prepared. Even the amicus curiae is also prepared. Your lordship can dispose it of item 17. The amicus curiae on the last occasion, your lordship has appointed. 17, your lordship will dispose of. I will assist your lordship to the best of my.
Okay, give a date for this case. Huh? 18, what is the next case?
17 to open.
I have appointed him amicus for the
Info-
informant, isn't it?
Informant.
It was a 417.
470.
Right. Now, my lord, I'll just sum it up, my lord. This case, my lord, 4 witnesses were examined,
Mm.
promise to marry, and physical.
Interesting.
Copy दिया ना.
वैसे ना, कौन सा? Yes, Mr. Bhattacharya, what was your matter? Because time, there is a shortage of time, and I mean, Jahan was also there. I have engaged them in.
Well, regarding the sanction against the police officials.
Item
Well,
16, Lordship.
Huh?
16.
Jahan is gone. Okay, fine. We'll take her matter on other day. What to do? Could not complete. Mr. Bhattapur,
Next day. It'll be on Thursday. my lord.
all these are 2012. Yes,
Yes,
what
sir.
is your case? Mohanto, what was your case? The doctor?
It was my complaint was dismissed by the session judge on division for want of sanction. Lordship.
Okay.
My case is that in this matter, present facts, no sanction is required.
Departmental inquiry was held, my lord, and department has found that he's.
Do you have any contact with your client?
Yes,
No.
I got.
He's still interested. Okay.
Sanction was not given. No, sanction was not given by the session court, my lord.
And
This-
who was for hearing matter? Somebody came here and wanted to.
That is probably also 2021. I am in 21, 20 days of trial.
20 lakh.
And 22. And 22 is also 417, my lord. 6 months jail. my lord.
Okay, let us see one by one. Okay, we are next in item number 17.
Hardly take 5 minutes.
Just wait for you. Wait for your turn. Let others are waiting, therefore we do not keep them waiting, isn't it? Everybody will have their chamber in the evening. And he's having a thankless job, my gosh.
Lord,
Yes, now 18, who is 18?
Better when the
What was some important issues were there, that's why you have.
magistrate passed an order that was treated as complaint, that matter, Lord.
Now slowly I am convinced in your favor.
Therefore, Ms. Jahan was also.
2019, we will take it up in January. As part heard. Item 19, hard in part, list this matter in the. No, maybe, no, this is item 18. 2019. List this matter on, give a date. 28th of, today is. No, it cannot be part heard beyond 9th of January.
8 or 9, Lord.
Give a day, we'll see on 8th or 9th. I think a signature will be, that a format will be required. Otherwise, anything and everything. This is
Other persons will be bound by that order, Lordship.
That's why. That's why I need to apply. Format. Otherwise, anybody will
Order has been sent.
send to treat it to be a
I'm also-
complaint.
It can be.
Can be.
Other day, because other day I was
Because
there.
if you go through the complaint, definition of complaint, it says oral or anything. But so far relating to complaint under this act, there is a specification signed. So signed will mean, will it be an order only?
Authorized to other persons.
Other
also.
person, if somebody not authorized, then also he'll have to sign it. Authorization is a part.
Order.
Anyway, we'll deal with in the
Alright.
month of January.
Sure.
Okay, then item 19.
In this matter, Mr. T. Dury is appearing, Your Lordship, but however, Your Lordship, due to some personal difficulties, government,
What is the,
Anyway-
what is the issue here?
Your Lordship,
Huh?
Trap case.
CBI, Lordship.
Okay, when?
Immediate Lordship, as per Your Lordship's convenience.
Your date from you is difficult.
I am always available.
You are always available in the courts, but not in the court. There is a difference between available in the High Court and available in a special.
No, I am always.
Because you are the only man, only lieutenant. You need some other lieutenants.
I wrote many times, Lordship. What can be?
We'll handle it.
Uh.
Let the situation come. We know how to handle this situation. We'll handle it. When we'll start engaging amicus for CBI to assist, we cannot assist appoint public prosecutor, but we engage amicus to assist on behalf of defense, and it will go viral that CBI is helpless, and we'll record how many orders we have passed. Asking that one CBI counsel is difficult. We will not blame you because it's not possible, humanly possible on your part to attend 4 or 5 criminal courts. We'll handle it. You just give them the message that we can handle it. Yes, give a date. 16/12,
Much obliged, Lordship.
next Monday. Yes, Bothakur,
Lordship.
your is also 2011.
Lordship.
What is this? What are the issues here?
Issues, Your Lordship, this is
How much time it will take for this court?
I will take half an hour.
This is against conviction.
Conviction.
You will take half an hour. Then PP will take half an hour. Okay. Give a date. Huh? 28. Okay.
Number 20, Lordship.
Yes.
Or 19th, Your Lordship. 20 is the last date, Your Lordship.
But for this court, there will be no motion. Okay, we'll see on that.
Lots.
No
Alright.
assurance, we'll see on that. If
Lots.
motions are given, everybody will busy with motion. Why should they do all these old methods? More particularly, Mr. Botha will be busy roaming for motions. Yes, what is 22?
Obliged.
Bhattacharya.
Hello.
Hmm.
Who does?
What?
Your Lordship was supposed to pass an order on that day.
What was the issue?
My lord, he promised to marry according to the accused, my lord,
Ah.
but did not materialize. And now they both married separately, living peaceful life. And payment has been made also, 5,000 paid as per the Lordship's order. So recent judgment was also there, living for 4 years, and misconception of facts cannot attract 414, 417. Which my learned friend will argue on this point also, this item number, Mr.
That
Biswas.
you know,
Same,
that-
he got 1 year, I got 6
So
months.
this item 12, item 22, and your matter we are not taking today. This matter. This will dispose of this matter together. When?
Yes, Your Lordship. When?
It'll take 5 minutes for me.
I know that, but it will take 15 minutes to dictate and at least,
Yes, sir.
isn't it?
Yes, yes. Your Lordship will let.
Give a date,
So,
same date for 22 and your is
17.
17. 19? Thursday,
19th.
19.
19th, my lord, that will be Friday.
No, আপনি একটু process হবেন
It
প্রায়।
was-
Oh.
25 calendar.
Thursday.
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 Yeah.
Thursday we'll finish it up this matter.
Yes. Thursday, next Thursday.
Item number 17, my name may be
Okay, in item number 17,
আমার তো কিমান দিলে?
no, it's 17 and
Table
22
one.
on the same date. Oh, same date. Registry to reflect name of Mr. V.H. Choudhury, learned amicus in this, in the cause list. Hmm. Sixteen. Yes. 16 also 2013. Sanction January.
January. Okay.
It's not so important.
Okay.
Yes, then what are the 23? Which one?
First week of January, man.
16, 8th of January.
23, man.
23, what is that?
Yeah, condition under NI Act, my lord. Fine only imposed, my lord.
Pay the fine.
Also upheld by the appellate court.
We will also,
After-
we will also appeal. Concurrent findings.
After vacation.
After vacation,
As your lordship, please, maybe.
2014, okay, give after vacation. Or Bihu vacation, after Bihu vacation. 0. 28th of January. Enough. How many matters tomorrow? Where is CBI?